Greetings, class. This is Professor McKenzie again. Today we're going to be looking at Chapter 10, which the title of this chapter is Real Assent. The learning objectives for this chapter, I want us to be able to understand and explain that contracts require what is called a meeting of the minds between competent parties, and if there is no such meeting, then the agreement usually is voidable. So we're going to come back to that topic that I mentioned from Chapter 8, where we kind of discussed, if you remember, the continuum of, valid, voidable, and void contracts. So here, if there's no such meeting of the minds, we're going to talk about how those types of agreements are considered voidable. Parties must enter into contracts voluntarily without duress or undue influence. That's another kind of element that I want us to discuss in this chapter. When we're looking at misrepresentation or fraud, that also, undermines the existence of a contract. And if there's a mistake, how we deal with mistakes in contracts. There's usually unilateral, which is a one-sided mistake, versus a two-sided bilateral mistake. And we'll go through some examples. And that will give rise to whether the agreement is enforceable or if it's voidable, potentially. So that's the overall kind of like learning objectives for Chapter 10 in our textbook. So getting to contractual capacity. So an agreement that otherwise appears to be valid, you kind of check all those boxes off, offer, acceptance, consideration, lawful purpose. But if there's a misunderstanding that goes to the very core of, one's ability to contract, then that could be because of age. So I've mentioned before, if someone is a minor, if they're under the age of 18 years old, if they're under the influence of, let's say, medication, drugs, alcohol, or illness, or just a general lack of understanding as to the nature of what they're agreeing to because of maybe some other condition, then we're going to treat those types of contracts usually as voidable. And so, again, voidable is optional. It may be a good agreement. Maybe you bought a used car or a used motorcycle in the neighborhood at 16 years old, and it was a good deal, and you kept it. That's fine. But if you change your mind, or if there's problems that you encounter before you reach the age of 18, you can return it, and the law provides you some protection there. And so that's that voidable aspect of it. You don't have to return it, but if you so choose, you can do so. So regarding minors, so people that are under the age of 18 years old, they can avoid most contracts as long as they do so within a reasonable time period. And reasonable is up to the point where they reach majority, so up until they reach 18. And in a lot of states, you're even given a little bit of time after that, but that window, is very narrow after you reach 18. Once you reach the age of majority. But if you're still a minor, obviously you have a lot more latitude there because the expiration hasn't hit yet. If you decide that you're going to keep something that you purchased as a minor and you have it into adulthood, then once you get past that reasonable time period, then you are considered to have ratified the contract. And so even if you have a valid reason in the future, you're 19 or 20 years old, to rescind or make a transaction voidable that you entered into as a minor, you waited too long because it was ratified. Generally, what the minor has to do is to return whatever they have received in the form of consideration. So if it's property, services, if it's a service, you probably can't return a service. But anything that is returnable, that is your duty as a minor to return. In exchange, you were entitled to get back what you were entitled to. What is not considered a voidable contract for minors is if it's for a necessary. So necessary includes medical care, educational loans, insurance policies, sustenance, shelter. So those are examples of agreements where we're going to say the minor is going to be bound by it, or maybe their parent or guardian, depending on the situation. The original consideration has to be returned, even if it's damaged. Different states have different, principles or standards to apply if the consideration has been damaged. Some states basically say it doesn't matter if it's damage, you have to give a full refund. Other states will allow the other party to the contract to offset maybe some of the cost of those damages. But at least in principle, the minor still is allowed to return whatever it is in question before they've reached the age of majority, and if it's not a necessary. The other category involves mentally incompetent persons. So if someone is dealing with, whether it be from disease, if it's from, a condition that you were born with, or maybe because of maybe an accident, if you are unable to kind of cognitively understand the nature of what you're entering into, then that functions very similar in terms of voidability, like a minor. You can just elect to say, look, I don't really understand what's happening here because I have fill in the blank, whatever the situation is that impairs your mental capacity. Usually what happens is that there has to be some kind of affirmation from medical experts. So it could be a physician, a psychiatrist, psychologist, to say yes, they have this condition, and then that justifies that kind of saying, I don't understand what's happening and I don't have capacity, and so I want to get out of this contract. I did mention before in the previous previous chapter, if your incapacity is to the point where you have a guardianship placed over you, then any agreement that the person who's being guarded enters into is just per se void. Only the guardian can enter into those types of contracts. The person who's being guarded, they're stripped of being able to make those decisions. And so it's a big deal if you ever get a guardianship over another adult, because you're essentially controlling everything that person is allowed to do or not do. It's a very big responsibility. If we're dealing with intoxication can come up in a variety of different ways. There's voluntary as well as involuntary intoxication. It could be because of alcohol. It could be because of drugs, legal or illegal. Even legal drugs like prescription medications. Sometimes prescription medications have like side effects, and one side effect could be that maybe it kind of clouds your judgment. And so again, if you can discern that's actually what happened, then you can say, I want to back out of this contract because I didn't understand the nature of what it was. I give the example here. I mean, obviously it's kind of a humorous example that usually is in pop culture, in TV shows or movies, where someone goes to Vegas and they have some kind of crazy night, and then they wake up the next day and they realize they're married. Obviously, marriage, I don't get into marriage law too much in this course, but I discuss it a little here and there. But marriage, before pomp and circumstance, before it's a religious thing for many people, according to the government, marriage is just a contract. That's all marriage is. It's nothing else to government. So like if any of you have either have been married, are married, or will get married one day, when you get a marriage license, that's government acknowledging this union of two persons through contract to merge their lives together. That's all it is. Again, it may be something very special for the two people involved. It could be very deeply religious. It could be like from a friend's reference. Maybe you found your lobster. I don't know, but at least the government. The only thing that the government considers a marriage, it's a contract between two people. That's it. Anyway. So, let's say, you do get married, well, in Vegas, and you were intoxicated. That's your defense. You could say, look, I was so intoxicated, I didn't understand what I was doing. And so what you're asking of the court, essentially the fancy term is an annulment, but you're asking to just kind of say that this contract never happened. Why that is important in a marriage situation is that even if you're married for a very brief window of time, if you're going through a divorce or dissolution, that usually, requires some kind of asset distribution. But if you can just say, I want this marriage annulled, or just pretend that that never happened, then there is no property distribution at that point. So again, hopefully this is a lesson that, no one ever needs to use. But if it ever does pop up, just know you want to go with an annulment, not a divorce. But again, this goes to the broader category of intoxication. What we're talking about here is just if your judgment is so clouded that you just don't understand the nature of what you're agreeing to. Again, these are avoidable. It's not required. So, maybe you do wake up married to someone in Vegas and you realize this is fantastic, and so you're happy. That's fine. You don't have to get an annulment, but again, just understand what your rights are because of this impairment of your legal capacity to understand that a contract exists. When it comes to mistakes, there's two general types of mistakes. There's unilateral, which I'll talk about here. Next slide, I'll get into bilateral mistakes. If a contract is deemed to have a mistake, it is possible that the party that is suffering can be the one that requests to kind of make the agreement voidable. Again, you don't have to, but it's an optional thing. What we look at here is, what is the knowledge of both of the parties that are involved, and it's specifically the party that was not the one who made the mistake. So if the mistake is unknown to the other side, that usually doesn't affect the binding character. And I'll go through some examples after this. But if the mistake is known by the other contracting party and they try and maybe take advantage of that mistake, then the agreement's going to be found to be avoidable at that point. So I give the example here of a seller who misquotes a price to a buyer. So maybe, let's say you work in office supplies, you're a wholesaler, and you're reaching out to an office, and you're cold calling, and maybe current accounts, new accounts, doesn't matter, and so you talk to someone and you say, look, this is what our company sells. We sell staplers and paper and toner and all this different stuff. And let's say that you misquote a price. And if the person you're calling, if they don't realize that it's a mistake, they just say, okay, yeah, well, we'll take maybe a new copy machine. And maybe instead of $1,000, you quote a price of $100. It's like if the other party doesn't know, generally we're going to say that's going to be enforceable. If the party did know of the mistake, and this is what can be hard to prove at times, it's very situational specific. How do we prove that the party knew that it was a mistake? Well, if the person on the other end of the conversation, the buyer, says, I'll take one copy machine for $100, well, that may not be proof that they knew that there was a mistake. But what if they say, I'll take 10 of them? Well, okay, there's going to be, even though it's maybe circumstantial, there's more credibility to kind of say, if you're the seller, to say, look, this seems like it's a mistake that was known, and the other side's trying to take advantage of it by buying 10 of these copy machines. And so because of that, we want to make this a voidable agreement. We're going to back out of it. And so that's how you handle a unilateral mistake. If it's one-sided, the party that did not make the mistake, we're trying to assess, did they know or not know of the mistake? If they had no knowledge a mistake occurred, full speed ahead. It's a contract. If they knew that there was a mistake and they were trying to take advantage of it, then we can get that party out of the contract at that point. When we talk about a bilateral mistake, now we're looking at a mistake that's occurring on both sides of the transaction. So if both parties are mistaken about a basic material fact of the contract, the adversely affected party may avoid the contract. So a material fact could go to, price, quantity, terms, delivery, method of delivery. Those are things where, again, we want to make sure there's a meeting of the minds. And if there is not a meeting of the minds, the party that could be adversely affected can say, I want to opt out of this and make it a voidable contract. However, if what we're looking at is a mistaken judgment, or let's say the perceived value of what's being contracted, as long as both parties are incorrect in the same way, then the contract's going to be enforceable and not going to be voidable. The example I give here, the current author of our textbook doesn't give this example, but it was an example from another textbook, which was a great example. Involved a seller had a racehorse, and the racehorse was getting older. And so the seller decided that he wanted to just sell the horse, not as a racehorse, just as a horse. And so that, lowered the value of this particular horse. A buyer comes along, they kind of do their observations, they kind of test ride the horse, and the buyer has the same impression that, the buyer understood this horse used to race, but now because of age, it doesn't think that, that the horse can do any more races going forward. So they agree upon a price, and, mutual consideration, money is transferred, the seller gives the horse to the buyer, they go their separate ways. Months later, the seller discovers that the buyer is now entering the horse in races and is making a lot of money off this horse. So the buyer is kind of contacted by the seller, and the seller is saying, look, I need more money, or I want my horse back. And so an actual lawsuit ensued. And, the principle that the judge applied was, well, what was the mistake that occurred here? And both parties acknowledged that at the time of the sale, they thought that the horse was not going to race anymore. So they both had the same diminished perspective or opinion when it came to the judgment value of that horse. The fact that the horse later seemed to have some pep in it and it could actually do races, that was just like good fortune for the buyer. The buyer does not have to give any consideration or give the horse back to the seller at all. It's a classic example of a bilateral mistake that we're not going to say is voidable, because the judgment mistake that occurred was the same judgment mistake on both sides of the contract. So even though the meeting of the minds was wrong, they were still meeting in the wrong way together. That's what's critical for a bilateral mistake in that situation. Misrepresentation. So if there's some type of fraudulent statement that's made with some sort of, it could be knowledge of its falsity, or it could just be a reckless indifference of the truth. You have to be able to demonstrate, that falsity, that there was an intent to have the listener rely upon it, the result that the listener does rely, and that the listener ultimately is harmed because of that false statement or that statement that was made with reckless indifference. If you can satisfy all of those conditions, then it is considered to be voidable, that contract, by the harmed party. Generally, statements of opinion are not going to be considered fraud. And so I give the example there. I love the holiday movie Elf. And if any of you have seen that movie, there's one scene in the movie where Buddy is going through New York and he sees this sign where it says world's best cup of coffee. And he runs in and, he's in classic Buddy mode. He's so excited and he congratulates everyone on having, created the world's best cup of coffee. Now, the reality is we know that's not the best cup of coffee in the world. That's like, it's considered in marketing puffery. When you say statements that maybe are so over the top, maybe bombastic, that whoever hears it or reads it or is exposed to it, they know that, okay, this is just over the top. It's just to kind of get your attention. That is not considered fraud, because your person of average intellect knows when they say this is the world's best coffee or world's best burger, we know that that's not the case, so. But again, if it's a material misrepresentation that's false or made with reckless intent, that results in someone acting on it and actually becoming harmed, the harmed party does have the option of making this agreement voidable at their discretion. Misrepresentation. So here we're kind of getting to non-disclosure. The general rule is that there's no legal duty to volunteer information to other parties. That's kind of like that, that Latin phrase, caveat emptor, let the buyer beware. But there are exceptions, because, we know the law is filled with a lot of different types of exceptions. If the seller knew of a serious defect that cannot easily be discovered, then obviously that would be, grounds to say, that there was misrepresentation there. If the parties are part of a confidential relationship. In business law too, I talk about different business entity forms, so we talk about sole proprietorships and partnerships and corporations and, LLCs, LLPs, all the different variations. Partnerships are a great example where I've seen some partnerships where it's a fantastic relationship, that's either, between or among friends, family members, business associates, whatever, and, they're very successful and very happy. I've also seen, unfortunately, some partnerships where it is very, very divisive, and each partner is trying to kind of, backstab, metaphorically, the other partners by maybe diverting, partnership opportunities to a side business. So, that's one of the exceptions. If you're part of that confidential relationship, like in a partnership, you do have an affirmative duty to reveal information. You can't just say, well, it's caveat emptor, because you are in that special relationship. The last exception is if the seller takes affirmative steps to actively conceal the defect. Again, this goes to, maybe, they can kind of hide things in a way that the buyer may not discover, for days, weeks, months, whatever, years. And again, upon discovery, even if it's 5 years later, doesn't matter, that's going to trigger, and it can be voidable at that point, at least from the perspective of the harmed party. Pressure, we have it as a premise to contracts in the United States that people enter into agreements because of their own free will, and that there's nothing else that's kind of going on behind the scenes that is, kind of inducing someone to agree to something that they don't want to agree to. But if you can demonstrate that, you didn't have free will, or that there was not a voluntary kind of acceptance of the terms, the contract possibly can be deemed voidable, which means, you can say, I want to back out of this. It could be undue influence, where maybe the beneficiary of the contract is, a party that is of extreme power in the contractual relationship, and you felt like you had no choice. Again, you've got to be able to demonstrate that, but that's a possibility. There's also something called duress. Duress can either be physical or it could be, economic. Physical duress, that's usually very blatant in that, this is where, you got to sign this and agree to this, or you're going to physically be hurt or your property. So, there's the threat of an actual crime against you if you don't kind of comply. You could imagine a situation where someone, if you are in that situation, you may not want to come forward to kind of make the agreement voidable. But again, you do have this as your right if you can establish and prove that there was this physical threat of duress. The other example, this is more veiled, is economic duress. And this goes against that notion of free will. The classic example is Richard Case and Katahdin Manufacturing Company. Rick Case, he sells bicycles. And so not only does he sell bicycles, he repairs bicycles. And so he had an agreement with this manufacturing company that they would supply bikes and parts to his store. And it was like an exclusive, supply. And so, and it was, kind of like basically on an annual basis. So, from year to year, Rick would re-sign up and say, okay, I'm going to have you be my sole source again. Anyway, it was near the end of the year, and they were kind of negotiating, the next year's contract. But there still was a few months left on the existing contract. And he noticed, Rick, that the manufacturer was kind of behind on sending some of the parts that he needed to repair bikes that people had brought in. So he called the manufacturer and said, look, you're behind on this shipment. I'm waiting for it because I have customers and I'm trying to repair their bikes. And so the manufacturer said, well, okay, I can send you those parts, but I want you to sign another annual contract first. And so you see what the veiled threat was, is that, I'm not going to send you your stuff now until you sign a new contract. And in reality, those were apples and oranges. Those two things have nothing to do with each other. There was already an existing contract to be the source for parts for Rick. And so what he did, appropriately, he said, okay, fine, I'll sign it. And then the parts were shipped. And as soon as he got the parts, then he terminated that contractual relationship. And in the course of litigation, Rick understood business law enough that, just because you sign something, it doesn't necessarily mean that it's enforceable. And so he was able to demonstrate that, he was being, suffering from economic duress or extortion, that, unless he signed another contract, he would not get the supply order for the existing contract that was prevailing at the time. So again, very fascinating case. But again, whether it's undue influence or if it's one of the two forms of duress, physical or if it's economic, that, if you can demonstrate that in a court of law, then you can take that existing contract that looks otherwise valid and complete and enforceable, you can make it voidable at that point. Remedies. So when there is fraudulent misrepresentation, the law provides for a number of possible remedies. Rescind the contract. What that means is just cancel it. And a lot of times that's just what the parties want, or at least the party that's complaining. It's like, I just want out of this. It's a bad deal. You could possibly affirm the contract, but then maybe permit some kind of action to recover damages, either in equity or maybe as per some kind of state or federal statute, which also could include punitive damages. So again, your attorney will kind of advise you what the best course of action is in terms of what's best. It's going to depend on the plaintiff and the nature of the facts in that particular situation. The standard of proof for the plaintiff in these types of cases, the standard is called clear, cogent, and convincing evidence. So it's a little bit above the preponderance of evidence. It's certainly not anywhere near, beyond reasonable doubt, because that's just a criminal thing. But it's a medium level type standard of burden of proof that you would have to be able to show as the plaintiff going after the defendant. I want to discuss two quick problems with this chapter. I don't always cover problems at the end of each chapter, but these two I thought were interesting. This one involves, the age issue and contracting. And so it says here that Helen, she's 17 and she wanted to buy a motorcycle, and she didn't have the money to pay cash, but she went to a dealership and they sold her a motorcycle on credit. She had a fake ID that indicated her age as 22 when in fact she was 17. She drove the motorcycle away. A few days later, she got involved in a minor accident, and then she took it back to the dealer and said she wanted to disaffirm or avoid the contract, and she just wanted to walk away from it. And the dealer said she could not because of two reasons. One, she had misrepresented her age, and two, the fact that the motorcycle was damaged. And I kind of asked, can she avoid the contract? Why or why not? And so, this is, I enjoy having this discussion in the classroom, when I have face-to-face, interactions with students. And, what I want students to understand here is that even though she lied about her age and she had a fake ID, that still does not necessitate or undermine the fact that she is still a minor. Minors, for those of you that, can recall, being under the age of 18, I remember what life was under the age of 18. Sometimes you make not so good decisions. And, the spirit of the law in this situation is that even though it may be harmful to the retailer or the adult in the transaction, we want to give deference to the minor, because we know that, that sometimes adults, are willing to take advantage of, the innocence of minors, especially in a contractual sense, so that, they'll agree to something that maybe is a bad deal because they just aren't savvy enough yet. Anyway, so the fact that she had a fake ID doesn't matter. She's still a minor, so she can disavow the contract. Does it matter that the motorcycle was damaged? No, she can still return it. This is where it'll vary from state to state. Some states might, say she has to offset, some consideration to compensate for the damage that resulted. But again, in principle, every state acknowledges if you're a minor and if it's not a necessary, you can return it at that point. The dealer does really own this mistake because, it says in the facts that she financed it. And, whenever, you can try and say that, well, we had a fake ID. Okay, that's fine. But if you involve any kind of financing, if you don't already know this, they have to pull your social. And so whenever you pull someone's social security number, you can definitely get precisely what their age is. That you can't fake. And so they should have known. And if they didn't, they should have. So the odds are they probably did know, but they just wanted to sell a motorcycle. That's probably kind of what happened. And in this case, it kind of came back to bite them. So she's allowed to return the bike, and they have to return any consideration that she forwarded to them. The last problem I want to discuss here, we haven't gotten into the details of agreements not to compete. But in this is a contract, and it's a barbershop. And if any of you have ever worked in like a barbershop, or if you know anybody, or like a beauty salon, hair salon, A lot of times, owners require, the stylist or the barber to sign agreements not to compete. And normally, there's two dimensions for any agreement not to compete. There's the geographic scope. So that's like, how many miles away, do you have to go outside this bubble in order to work? And then there's a time element as well. And so in this contract, the elements of time and geographic scope are fine. There's no issue here. And when we get to that part of the course, I'll talk about agreements not to compete in more detail. But the agreement itself is not a problem. Normally it's going to be a valid contract. But it says here that Thomas Bell, a miner, went to work for the Pittsburgh shop of Sam Pankis and agreed that when he left employment, he would not work in or run a barbershop with business within a 10-mile radius of Sam's for a period of 2 years. So that as an agreement is not a problem, just in theory. Contrary to this provision, Bell and another employee of Pankis opened a barbershop 3 blocks away from Pankis and advertised themselves as his former employees. So they were pretty bold in doing that. Pankis sued to stop the breach of the non-compete covenant. Bell, the miner, claimed that he was not bound because when he was a miner, he had agreed to the agreement, but still he was a miner. And the question is he bound by the covenant or not? Why or why not? And again, in a traditional classroom setting, the first thing that I'll have students, try and understand is, what do we know about contracts when it involves someone under the age? And so students will kind of recite, well, okay, we know that if it's not a necessary, and an agreement not to compete is not a necessary. So it's like, okay, potentially we're not going to impose this on him, but we need more information. He signed it when he was a minor. Is he still a minor? And so that's usually the critical question that needs to be answered here, because I don't give you that information in this problem. So if Bell is still under the age of 18, there's no way Sam can impose the agreement on him because he's a minor. So, if that's the situation, case dismissed. No problem there. If he's over the age of 18, well, we need to know, okay, in Pennsylvania, what is that time window? Because we know there is a reasonable period of time after you reach majority that will allow you to disavow a contract. But then once you go past that time deadline, then going forward, you've ratified it. And even though you entered into it as a minor, you're going to be bound by it now as an adult. So, the question that has to be answered is, well, if Bell is an adult, how old is he? Is today his 18th birthday? Did he just turn 20? If he's beyond that reasonable time window, then I want students to understand he's going to be bound by it then. And he's going to have to, look to a different location that is beyond that 10-mile bubble, or wait 2 years. That's essentially your two choices. But anyway, I hope this helps. I hope this was an interesting chapter for you all to study. As you have questions like normal, please feel free to call, email, text me, whatever is easier, and I'm always happy to answer any questions that you might have. Have a wonderful rest of your day, and I'll be chatting with you all soon.